Hello, everyone. I'm Marguerite Ro. I'm the State Director for AARP Washington, and we're here having a conversation with Linda Davenport from BECU as part of our Caring for Caregivers conversations. Today, we're going to be talking about caregiving and finances, and I'm very excited for you all to meet Linda. Hi, Linda.
Hi, Marguerite. Thank you so much for having me.
So glad that you could join us today. Do you want to tell folks a little bit about what you do at BECU? And I also know that you're a caregiver.
Sure, yes. So I am the Vice President of BECU Trust Services. And what we do is we act in a fiduciary capacity, which basically means we can act as executor and administer an estate. We could act in a role as a trustee or even an agent and, serve in those roles as an agent for someone like a family member that may have been appointed as an executor or as a trustee of a trust. And yes, I am a caregiver myself. I have a mom who's 82 years old. And so I think by default, my family has deemed me to be the caregiver. And so I spend a lot of time, of my own time taking care of my mom. And most recently, it was basically 5 weeks, spending 5 full weeks with my mom and challenged with, work. And I have a family too. And so it was a lot of heavy lifting that I know that I experience and I know a lot of other people experience as well.
I know it's a lot to take on that caregiving journey. But one of the things that I was so excited when I met you was to talk about what do you need to have in place?
Sure.
As we think about as we get older and as our loved ones get older, what are some of those things that and documents that we should be thinking about?
Sure. Well, I think the estate planning documents are documents that so many people procrastinate in getting, drafted. And that can be really problematic if an event takes place and somebody needs to step in and assist someone. So I would say everyone really needs to look and get a will drafted. Even if you don't have a lot of financial assets, a will can also help young couples. Let's say if they have, a child where they appoint a guardian for their child in the event anything happened to both parents. So a will is not just for folks that have a lot of wealth. It really is for everyone.
So even if I'm a renter and I don't own a house, when you say estate, what do you mean by estate? So,
yeah, I mean, an estate it really encompasses all of your assets. So, it could be investments, your 401k. But like I said, a will is not just for folks that have a lot of assets that they've, accumulated over time. There's also other things addressed in a will for younger couples that it's very important for folks to have.
At what age should somebody begin thinking about putting a will in place?
18.
Oh,
and
wow.
I'll tell you why. And the reason is because typically with a will, there are other documents that are just standing documents that stand aside, with the will. And those are a healthcare directive. And that would be in the event someone were, terminally ill and had that diagnosis. It's an end of life decisions. And then also power of attorney documents over healthcare and financial matters. And these two documents are super important while someone is alive. Because let's just say, I had, let's just say I was in a car accident, right? And I wasn't able to make my own medical decisions. That can happen to anyone at any age, right? And so whomever you have appointed as your agent or attorney in fact would be able to step into your shoes and make those healthcare decisions on your behalf. It also applies with a power of attorney over financial matters. And that really focuses on the financial side of things. So again, if something were to happen to me, and I have this document and I have appointed someone to be my agent or my attorney in fact, they will be able to step into my shoes and pay my bills, write checks on my behalf, any type of financial transactions, they would have the ability to basically step into my shoes with that document.
How do I figure out who I would trust? And when you say when it's needed, when does that power of attorney kick in?
Yeah. So there's two ways, two designations that you can put in your document. When that document would actually kick in with an event, right? The first is that some folks choose the option of having that document effective immediately. So as soon as they sign that document, if I'm the principal signing that document, I could put it as effective immediately. The other option is upon incapacity.
Mm.
And oftentimes we see in the document that it will designate or indicate that a doctor, a physician, right, would have to deem me incapacitated. And that's when the attorney in fact or agent would basically step in and, manage my affairs for me.
So, and can I change my mind at any time?
Absolutely. You can. You can, we have a lot of folks that, when they make this decision and they decide, okay, who should I appoint to be in these roles? Well, some folks are more comfortable with making healthcare decisions. And then some folks are maybe more savvy on the financial side. So, it depends kind of your family makeup and who you would feel most comfortable doing those things. But yes, you can absolutely change your mind. Let's just say you put someone in and maybe they move away, they move out of state. You probably want to have someone that lives local that you can change the document and put someone in that's more local, because it would be very difficult for someone to basically act on your behalf if they're out of state. It's not impossible, but it's just a lot more challenging.
Do I need a lawyer in order to do this?
That's a great question. So, I don't think any estate plan is easy. There's because a lot of times there's family dynamics, right? And so there are options of having a document drafted, online. There's online platforms that you can use. But I would say if you have any concerns with any complexity or family dynamics that you're concerned about, that it would probably be best to go to an attorney and have an attorney draft the document. And they would basically draft the entire package, right? They would draft the will, they would draft the healthcare directive, and then the power of attorney documents as well.
And I think you mentioned something about trusts.
Yes.
What's a trust?
Yeah, so that's a great question. And this is, one of the most common questions that we get is, do I need a trust? Because people often get confused about a will versus a trust. A revocable living trust is a really good tool that can be used for a couple of reasons. If I say, for example, didn't have any family, right? And I was concerned with incapacity and who would be stepping into my shoes to manage all of my assets in a way that provides continuity. That would be an instance where a revocable living trust would be very useful. And so what that would mean is that I could be my own trustee currently, but if I became incapacitated, then the successor trustee would basically step into my shoes. All of my assets are titled in the name of my trust. And so if something happened to me, my successor trustee would be able to step in immediately, not necessarily have to take that power of attorney document over financial matters and go to every financial institution, because they're already written in my revocable living trust document. So again, it provides a lot of continuity. The other reason that a revocable living trust could be very useful is if I owned real estate outside of the state of Washington. Oh. And what that would do is that let's just say I owned a piece of real estate in Arizona. Uh-huh. What I would do is title that piece of real estate in the name of my revocable living trust. And if anything happened to me, that asset would not have to go through probate because it would be owned by the trust. And so I would avoid probate in another state. So that's the other reason that, compelling reason to have a revocable living trust.
Okay. So
yes,
I'm going to share my financial illiteracy with folks and say there's a lot of terminology to learn. Is there a thing that's not a living? Why is it called a living trust for one thing?
So it's a revocable, which means it can be changed, right? A revocable living trust is a document that is basically utilized while you're alive, but it acts just like a will when you pass away, which basically means that it's a document that's utilized while you're alive. somebody can step into your shoes while you're alive and manage, your affairs for you, right? And that could be during a partial, like maybe you're incapacitated for a short period of time, right? Maybe you've got a medical issue.
Yeah.
So, but it also addresses distribution upon your passing, just like a will. So a will and a revocable living trust can do all of the same things with, distributing your assets after you pass. The difference is the will is only used after death. A revocable living trust is used during your lifetime and after death.
Got it. Okay.
Okay.
You mentioned a term, probate.
Yes.
What is probate?
Yeah, probate is basically, it's a process. It's through, our state, right? And it is a legal process if assets, I'm just going to use, the revocable living trust. If we have some assets that are not titled in the name of the revocable living trust, those assets would go through probate. And if you didn't have that trust document and you only had a will, there is a threshold of assets. Like if you get over, if I recall, it's about 140,000, or if you have real estate, those assets have to go through probate unless there is a beneficiary designation for those assets. So anything that doesn't have a beneficiary designation and that's not titled in the name of a trust would go through the probate process. And there is a myth, Marguerite. A lot of people, are nervous about probate. Probate is not a difficult process in the state of Washington, and it's not a very expensive process. And I think that's a myth because there are some states that, the process is very cumbersome and it can be very expensive, but not in the state of Washington.
Is that handled by, there must be an office somewhere?
It's through the courts. Yeah,
okay,
it could be King County, Pierce County,
okay.
Right? Whatever court or whatever, kind of location that you're in or county that you're in, it would be through the courts. Mm-hmm.
Wow. So this is like a lot of information.
It is, yes.
It's a lot of information. How do I start? So, where could I start to understand all of this?
Yeah, that's a great question. So I think, before this is, my advice, right? Before connecting with a trust and estate planning attorney to get those documents drafted,
mm-hmm.
I would suggest that individuals reach out to their, financial planner, financial advisor, or a trust department, and just have meetings and talk about kind of the things that they are looking at doing, right, with their assets. Those discussions will allow you to think about options that you have so that when you go talk to an attorney, you probably should have a pretty good idea of what your vision is for your assets while you're alive and after death. And that gives you a pretty good foundation to start with the attorney. And the attorneys, trust and estate planning attorneys will walk you through options as well. But it's nice to be able to, think about that before you actually go to see an attorney and, have some time to decide, okay, do I want my assets to go outright to my child or children? Or are there spendthrift issues or, drug and alcohol issues with my adult child that maybe I have some concerns of? Maybe I want to have a trust instead for them after my passing. So again, it just allows you to really think about, different options and be able to make the best informed decision.
So I know I asked you at what
Mm-hmm.
age should you have a will? Is it ever too late?
No, absolutely not. It's never too late. And, I know a lot of people think, okay, the new year's coming, I'm going to get to these documents. It is never too late to get these documents addressed. And, one of the things that I encourage people to do is also talk to your family about your documents. So often it's not really, the information is not really shared, especially if, so for example, if I have an adult child and I want them to be the executor of my estate and basically, manage everything after I pass away and distribute the assets to whom I want in my will, but they don't know that I put them in my document, that could be a challenge because maybe my adult child says, you know what, Mom, I'm not comfortable doing that, right? And so I think it's, being transparent and talking to family about that. I also think, I'll share a personal story. My father passed away, and prior to him passing, the healthcare directive, which addresses when someone is terminally ill and end of life, right? I have 3 siblings, and I have one brother in particular that, he would have a really, really difficult time with choices about nutrition and hydration, right? Life-sustaining support and oxygen. So with my father, he completed those documents, and, we had conversations as a family on what my father's wishes were at end of life. So when the time came for those decisions to be made, I was the attorney, in fact, over healthcare, and it made it easier for my brothers to accept what my dad's wishes were, because we actually talked about it. And it also made me more comfortable, because it's a very emotional period of time. And knowing what your parents' wishes are, your loved ones' wishes are, and everyone else knows it, makes it much easier, to execute on their decisions, right? So, but yeah, that was a story I like to share, because it really shows the success of communication within the family.
I think I hear a common story that oftentimes with our parents or our older loved ones, that folks wait a little bit too long until people are either in the hospital or unable to communicate fully their desire. And that tends to be a challenge in trying to rush and put all of those documents in place really quickly.
Yeah, because if you wait too long, and let's just say you don't have capacity anymore, then it goes to a guardianship, and guardianship process is very expensive.
Okay, well, we won't go there, because that's a big topic that I know at some point maybe
we could do a whole separate segment on that. Absolutely,
we can tackle that one next. But another common scenario that I hear about is it's a married couple, and they've had more traditional roles.
Sure.
And suddenly, the wife actually has no idea, or one of the spouses has no ideas, because, it could be their husband or their partner has always managed the finances, and they assumed that all the paperwork was done.
Right.
What recommendation do you have for those individuals who actually don't know what's in place, or haven't even begun to think about these things?
Yeah, we do have those scenarios, right, that we run across. And, I think that, knowing that there are professionals that can help you navigate through that is important. So say, for example, we have, a husband and wife, and let's just say, the husband passed away, and the wife really doesn't understand anything about her finances, what they have, or, knows nothing about even the bills and that sort of thing. There are professionals out there, like our company, BECU Trust, or other trust companies, or, they may have a financial planner that they can go to and talk through, to get the help and support that they need to understand what their assets are and how to get those managed. There's a lot of professionals that can help with that. The other thing, as I alluded to earlier, is just open communication. Really talking about, and sharing and giving information to each other. And at a minimum, sometimes there's also, maybe a spouse that doesn't want to know. It's like that, that's information I don't want to know because it's too complicated for me. But if there's other family members that could, learn about what assets are out there, what accounts are out there, and have a list, right? And just develop that list that you can actually tell somebody, where is that list at, right? Of all the accounts, bank accounts, investment accounts, where do you hide your safety deposit box key, right? Codes to safes that might be in your house that store jewelry or documents. Having just a simple list and listing those things out could be very helpful for the family as well.
So going back to this idea of like everyone should have a will or some kind of trust in place. What are the assets that are most likely to be overlooked or not considered that you run across?
Yeah, well, I don't know that there's necessary. Well, life insurance might be some, right? Sometimes people have old life insurance policies that are stuck in a file cabinet that are collecting dust that people forget about. So, if an event happens where somebody passes away, looking through those file cabinets, trying to locate life insurance policies, those are some assets that are overlooked. Personal property is kind of one of the assets that probably most people fight about. And that is something that I think people should probably address, during their lifetime, because those are, like I said, the things that most people kind of argue about, right? Is the
Yeah.
personal property assets.
Yeah. I think one of the things that I've learned where you have said that, in fact, the bank is sometimes an agent for you.
Yes. So we can act as an agent for somebody that is appointed as an executor or as a trustee. So like, say, for example, if their parent passed away and they're an executor and they're like, I have no idea what I'm supposed to be doing, they can come to BECU Trust Services or to any other trust company or their financial advisor and ask, can they support being their agent for them so that, they're working with folks that understand this process, because we do this day in and day out.
Yeah.
Most people don't have this experience. And unfortunately, sometimes they can make decisions that actually, could be detrimental to the overall estate. And they're legally liable as a fiduciary, as an executor, as an attorney, in fact. And most people don't realize that they have that legal liability and to do the right thing as a fiduciary. And if they breach that, they could get sued.
Interesting.
Yeah.
Okay. So there's a lot here.
Yes.
We should have more conversations. But let me ask one last question of you. Where should you keep your will and all these documents? I think I've even heard stories of people saying, oh, you should keep them in your freezer.
Yes. So yes, there's that out there too. Yeah. No, so the challenge is, safety deposit boxes are still available, right? They're getting less common, but they're still available. The problem is if you don't have someone listed to access that safety deposit box, they cannot get to those documents unless they're listed, at the financial institution to be able to gain access. So that can be problematic. Is it, can they never gain access? No. What happens is it ends up having to be drilled. Oh, so there's a solution. It takes a little bit longer. Oftentimes I just tell individuals, their attorney, oftentimes law firms, will hold the original documents. You can also get multiple originals and actually give the document to the person that would be stepping in as executor. Let them hold them in a safe in their home. And yes, I've known people to also put it in their freezer. I'm not sure I'm an advocate of that, but definitely, you can have a safe in the house and put it in there for safekeeping. Distribute copies to those that are actually going to be stepping in for you. Your healthcare power of attorney, your financial power of attorney person, whoever's going to be your executor. They should at a minimum have copies of those and at least know where those originals are.
When you say originals, does that mean hard copy, like actual paper?
Yes. So yes.
Electronic files won't work?
Well, that's another topic too in and of itself. Electronic copies can work. That gets kind of more into the legality. I'm not an attorney, so I would have to kind of, defer that question to an attorney. But yes, generally speaking, we are looking at a wet signature, hard copy.
Good to know. Good, I learned.
But there's always ways around that, right? There's always ways to address if you can't find an original. There's always ways, but the easiest and the best is, yes, access to that original is the easiest and the quickest way to, start getting the process going.
Okay. So I know I said it was the last question, but so going back to the hard wet copy.
Sure.
Does that mean it has to be notarized, or does it, or can it just be a photocopy?
Yeah. And again, that's a deeper conversation, because there's witnesses also, it's called a self-proving will. Again, that's a more complicated topic that we could probably get into in another segment. But what I would say is typically individuals will have two witnesses that have witnessed the signing of their will, and the witnesses' signatures are notarized.
Okay.
Yes.
So we definitely will do more on this, but let's wrap up and give people maybe the high level takeaways from this conversation.
Sure.
Really important to have a will or a
Yes.
trust.
The healthcare directive.
Healthcare directives are really important, and
Yes.
those give people the legal ability to help make decisions when you're incapacitated.
The healthcare directive is for end of life. So basically, it's a person stating what their wishes are at end of life. Then it's the power of attorney over healthcare that you were just talking about, right? That gives them the ability to make healthcare decisions on someone's behalf while they're alive. And then the power of attorney over financial matters that gives an individual the ability to conduct financial transactions, write checks for an individual, if they're incapacitated or are unable to do it for themselves while they're alive.
There's a lot to unpack here, but it's important that we think about planning, which is in part why we're having these conversations. So it's a good start to a conversation. We do actually have at ARP, we have what is known as the Financial Workbook for Family Caregivers. And in this toolkit, essentially, it lists it takes you and walks you through thinking through whether or not you have the documents that you might need to have in place for health, housing, money, and future planning. It's just a start. I appreciate the conversation. I look forward to future conversations and getting into some of these nuances. But I think what I'm leaving here from thinking is that it actually is going to take a little bit of preparation and planning to making sure that actually I have everything in order for my daughter. And I think I'm also taking away that, she's past the age of 18, and I know that we have not talked about her having a will in place, but that it's a conversation to have with my parents.
Absolutely.
As well. And it's something that we just need to
put it on the front burner.
Put it on the front burner, as you said.
Absolutely. And thank you. I appreciate being here and being able to give, really important information out to our community.
So folks, for more information, you should go to aarp.org/caregiversWA for Caregivers Washington. And we look forward to talking again. Thanks, everybody.